Hello, everyone. It's great to see some of you in person and to know that hundreds more are watching us online. My name is Clothilde Goujard. I'm a tech reporter here at Politico, and I'm happy to bring you the discussion today about the AI Act 1 year into the negotiations. The bill, which was presented by the Commission about a year ago, is the world's first plan to regulate AI, and it will seek to restrict the riskiest uses of AI, such as real-time facial recognition and government-led scoring. Before we begin this panel, we have an opening remark from our presenting partner, Google, represented by Marian Croak, Google's Vice President of Engineering, Responsible AI and Human-Centered Technology.
Good morning, everyone. I'm Marian Croak. I'm a Vice President of Engineering at Google, focused on responsible AI and human-centered technologies. It's my pleasure to join you virtually today at the Politico AI and Tech Summit, which we're happy to support for a third time. I just want to open up with some remarks to kick off the discussion among our distinguished panelists today. So I lead a center that conducts research and develops methodologies, technologies, best practices to help ensure that AI systems are behaving in a responsible way. And the foundation for the work that we do are Google's AI principles, which were launched in 2018. And they serve as the ethical charter for how we're going to develop and use AI systems. They include things like ensuring that AI systems are socially beneficial, that they don't create unfair bias, that they're built and tested for safety, and that they're accountable to individuals. They also specify which applications we will not pursue, such as surveillance applications that violate international norms. And you'll notice that many of these principles are quite well aligned with the European approach to AI regulation, which you would expect since we have a common goal to develop AI in an ethical and trustworthy way. Now, while these principles are important, what's even more important is how we put them into practice. And that's where the everyday work of my team comes in. Beyond the principles, as Google's CEO, Sundar Pichai, has said, AI is much too important not to regulate, and the biggest risk could come from not adopting it. In that respect, I'd like to share with you some of our thoughts around the AI regulations in Europe as well as globally. First of all, we think that the creation of a legal framework for ethical, responsible, and trustworthy AI is really a good thing to do, and we fully support it. We believe that this is especially true for high-risk applications, and that this risk-based approach is reasonable and proportionate. We also believe that many of the requirements outlined in the draft AI Act are fully aligned with Google's existing practices, as well as our AI principles, which sets a very high bar, which is a good thing. There are a few things, however, in the draft AI provisions which I think could benefit from additional clarification. Notably, the distinction or the division of responsibility between the balance of responsibility between AI users and deployers and providers of, in particular, general purpose APIs and open system models needs to be better distinguished. We also do believe that it's very important to clarify that pure AI research should happen in an unencumbered manner, and there should be no constraints imposed upon it. and that's for pure fundamental research. We also think that there are a few provisions in the Draft AI Act that could be problematic to actually implement in practice for high-risk applications. For example, AI systems, whether they're very large or small, are complicated. And to require that any individual fully understand a system appears to be infeasible. We believe it would be better to say that individuals are required to sufficiently understand the system in order to exercise effective oversight upon it. So these are just a few of our concerns that I wanted to share with you, and I appreciate the opportunity to do so. And I hope that we can continue to work together to create the right governance framework for AI regulation in Europe. Thank you again for joining us today. I hope you have a very fruitful discussion, and I look forward to working with you more in the future on responsible AI. Thank you again.
Thank you, Marian. And now on to the debate. Let me introduce some of our guests. We have Killian Gross, who is the head of the Unit for Artificial Intelligence Policy Development and Coordination in the Commission's DG Connect. And Killian has been the main policymaker behind the AI bill. Next to him, we have Claire Fernandez, Executive Director of the European Digital Rights, more commonly known as EDRI, for people who know the organization, and is a large network gathering over 45 European digital rights NGOs. Next to her, Brando Benifei, one of the main rapporteurs, one of the main key person in the parliament who will be amending Killian's bill, or the Commission's bill. Brando is a social democrat hailing from Italy. And last but not least, we have Axel Voss, a seasoned MEP from German center-right, and who will also be involved in amending the AI bill. And Axel has worked on other digital bills like the GDPR and the Copyright Directive. Before we begin, a quick reminder, don't forget to submit your questions via the Swapcard app in the questions box next to the live stream. And you can also tweet about the event with our hashtag Politico AI. Brando, I'll start with you. We're still waiting for your report to be published.
It's there, but it's just...
You sure it exists?
It's about to appear.
Okay. We've talked to you before, so a lot of media have already reported on what you and Dragos Tudorache, the co-rapporteur, want to do. Some of the things you want to change is you want to ban predictive policing, so algorithms trying to forecast crime. Yes. And you also want to add several other high-risk applications like AI systems influencing children or doing triage in patients in the healthcare sector. So why did you want to make these changes to the AI Act?
Well, we are doing a complicated exercise because we are trying to bring together the perspectives of two different MEPs in this stage, together with my colleague Tudorache. We have been bringing as co-rapporteurs in this first report all the points on which we are able to agree from now already. This brings this proposal strong on the table because it's already two MEPs, two political groups bringing these political changes, these amendments. Then we will move, each of us and all the colleagues, like also Axel here and all the other colleagues will bring further amendments in the new phase. What we agreed on in this phase with the colleague Tudorache was to, as you mentioned, enlarge some aspects of the high-risk categorization, for example, regarding children. We wanted to add some further transparency, like putting as an obligation to put in the register of the Commission all the high-risk uses for public authorities. We have, you mentioned the predictive policing, but also it's important to see what we didn't do, like we chose not to narrow down the definition. Obviously, we also already have issues where I'm sure that we will all bring different perspectives and that we couldn't agree at the beginning, like further restrictions to the prohibition of mass surveillance, the fundamental rights impact assessment. We are discussing about this. I cannot exclude that we will find some early agreement already, but otherwise we will go for amendments and then we will negotiate like we do in the parliament.
Mm-hmm. Axel, do you believe that some uses of AI, like predictive policing, for example, can be too dangerous and should be further restricted? Would you support some of these bans?
So good morning to everyone. So I'm not a big fan of banning everything and only thinking in protective dimensions. And so that's why I think banning is not wise, because you never know what will build up on this technology and another use case and then business case and so on. So that's why I would rather to see this regulated in a way. And sometimes I do not see why we have to discuss biometric data in the scope of the AI Act. So I find this systematically totally strange. And that's why I would say we should regulate this instead of banning, because there is privacy tech already available on everything, so that you can balance risk and chances, and you can define the access and the use of data and everything. But so banning, it's quite easy, but it's not the intention or not future orientated. And this is what I'm thinking sometimes we should do more instead of just doing one thing and trying to link everything what is possible. And predictive policing might not lead in every case to a kind of a result we would like to have to, but it might help. And therefore also banning is not, from my point of view, not very wise. So why we don't get the best out of new technology and then trying to limit what we do not want. Mm-hmm. But this black and white thinking is not my way forward. It's more the balancing issue.
Claire, do you believe that predicting policing can actually help? Are you of that point of view?
Allow me to like frame it in a different kind of way. I think at EDRI and other civil society partners, we particularly concerned about the context in which AI systems are used. So we're not advocating for banning technologies. We are talking about restricting some of these most harmful and unacceptable uses. The context is one of huge power imbalances between the institutions deploying those systems and the people affected, and the complete opacity about knowing how a decision was made. And the scale of the problem, I think, was reminded by Vice President Verstager. For example, the Dutch child benefit scandal affected tens of thousands of families who've lost their job, who've lost their houses. In some cases, their children, were taken away from them. And this was, this should be a wake-up call for Europe, that it's time to not just innovate our way out of it, but regulate strongly. So to go back on your points on prohibition, but also on the points that we would like to see in the reports and improvements in the AI Act. There are 3 types of improvements. The first one is that we need real accountability for deployers of AI systems. And that means in particular for AI high-risk uses, to have human rights and fundamental rights impact assessments and before deploying any high-risk system. Second of all, we need to empower people affected by systems. And at the moment, there is currently absolutely no right for people who have been affected by the system to receive an explanation and to have the ability to get redress if they have been affected by the situation. And in terms of having a comprehensive approach to the AI harms and the harmful uses, we not only would want to see banning predictive policing, which is a completely against the presumption of innocence. And we're talking about children as as young as 12 being predictive, a crime trajectory based on who they are, based on where they live, based on who their parents are. And that absolutely has no place in a democratic society. We would also want to see prohibiting all forms of remote biometric identification in publicly accessible places. I'm quite precise about that term, and we can go back to that, as well as any uses in the migration context that are, we are talking about people, vulnerable people on the move. And finally, all forms of social scoring by either public or private entities.
Killian, what was the thinking behind creating these prohibitions or creating this classification of high-risk applications? Why did you not, for example, include these? How did you decide, for example, not to include predictive policing in the bans or emotion recognition systems?
Well, thanks, Clothilde. To start with, I mean, what we tried is, and I think that already came out a little bit from the discussion, to find a good balance between innovation and regulation, because we want to create a framework for trustworthy AIs where people can rely on it, and at the same time, we don't want to basically prevent the development of the technologies. We need to find a fair and a good balance. And that's what we try with this risk-based approach, that we try to find risk categories and we adapt our intervention to the level of risk. When we looked at the bans, we were prudent because a ban is, of course, very, very strict and you can't do it at all. And you have to be sure that there is no beneficial use at all for a certain technology. And if you take emotional recognition, for instance, we think that there may be certain uses which may be laudable because, for instance, if you can help people with disabilities, for instance, to recognize emotions from other people, people who have visibility restrictions, who could use AI to understand better their counterpart, for instance. So is just one example. Or you could use emotional recognition when you have tried to distinguish in a call center in a hospital who needs to be served first. So if we want to go that way to say we want to ban something like emotional recognition, we should first be sure that there is really absolutely no useful application of this technology, and there we were not convinced. What we do therefore is we say we prohibit certain clear-cut cases, and we put emotion recognition, if it's used in a high-risk area, it will of course as well be high risk. So if you use, that's perhaps sometimes a bit confusing in the understanding, if you use emotional recognition in a recruitment context, for instance, to check the emotions of the person applying for a job, you will be in a high-risk context, and therefore the AI will be high risk. So we look here at the situations. I think that we are together, we look at not at the technology, we look at the situations, and if the situation is high risk because you're in a recruitment situation and therefore the decision taken is really important for you, then we declare this as to be high risk. And the same for predictive policing. We declare this to be high risk because we think it's of course a tricky technology, but we cannot completely exclude that there are some benefits to it. We have talked to police forces. We agree there is a lot of risk. There are dangers. That's clear. But there may be as well possibility in certain areas to identify, perhaps to help victims or to help people to protect themselves with predictive policing. So we think it's difficult to say outrightly there is never any useful application of this technology, even if we agree that there may be a lot of applications which are tricky. And just before I finish, let me say we should always, and that's I think a very important point, be aware that what we discuss here is basically how we want to make sure that the systems work if a society decides that they want to use it. We don't prescribe by no means that you have to use predictive policing or facial recognition or anything. There, I think it's very obvious because we even request the member state who want to use it to introduce a law to make use of the exceptions. We just say, if you want to use it, then you have to fulfill these conditions. And these conditions, and that's my last remark, not to be too long, come on top of what exists. Because we are always talking about a highly regulated environment where you have normally data protection regulations and other laws that you have, of course, always to apply. We only talk about legal applications, so the rest of the legal context must as well be taken into account.
Thanks, Gillian. Axel, you often talk about innovation. And so one of your worries is that the AI Act might be too burdensome for European companies. What would be the risk if the AI Act was adopted as is?
Oh, then I have to create this broader picture now. I see the competition worldwide or globally is on and on and on. And if we are thinking just in this dimension of protecting and banning and so on, we are not creating innovative ideas. We are not creating innovative technology. And if we are then coming with this mentality of a GDPR where we are saying, oh, please do not process data, then we are in the data-driven world, then I see us out of the game somehow. And if we are now coming with a kind of an legal tool where we are creating a second GDPR, complex and probably not for everyone not knowing what this means at the end. And what I'm hearing right now, that companies are going abroad, so outside Europe, to train their algorithms. And I'm pretty much sure that we will come up with a whole wish list how a result should be of an AI algorithm. And if we are not providing then these quality data for training your algorithms, we won't come up with a kind of an innovative product and a business model out of it. And then we will not come to a point where we are a serious competitor in the world. And AI is of high strategic relevance. So therefore, I would say we should sit more together and discuss how to move forward instead of saying, oh, just rushing and just banning and so on. This wouldn't be my way forward, and I do not see a very bright future if we are making this too complicated. It should be practical. At the end, it should give a kind of a guideline how to use it, and should not restrict everything. So, of course, we need some restrictions and to come forward and to balance. This is all clear. But I would be very careful in doing too much.
Brando, is Europe going to lose its edge in the global race for AI with the AI Act?
I think Europe is trying to build its competition model based on our values. And I have to say that I don't think we can risk meddling with the presumption of innocence. This is what we are talking about when we talk about predictive policing, because maybe we can have some good results. This is the idea why because we cannot put at risk the example that was made about what happened in the Netherlands, the case that I also discussed with Vice President Vestager when we had an exchange on the AI Act, is exactly what we are thinking about when we think that we need to be sure that, especially when dealing with some areas, there must be further checks before we destroy lives of people, of hundreds of thousands, and then maybe later on with market surveillance we find out we destroyed lives of people. On the GDPR issue that was mentioned, I have to say that we have been already
our
with
favorite subject.
No, we discussed a few times about that, but You will find out, Axel, that we just aligned with colleague Tudorake more the AI Act with GDPR, trying to avoid legal uncertainty. So this is what we try to do. Then you will see if you like it. But this is what is in the report that will at some point appear. As I said, we already deposited it, but it's just a technical matter. It will come out soon. Then on data. I think this is very important when we think about the competition. The requirement that was in the text, we amended it in the report already. The requirement of data sets free of errors. We thought that this can be an objective, but it cannot be a precise requirement. So we, in this case, for sure, we looked towards the demands that came from also the developers, not to have a too stringent requirement on that, because we think it's impossible to actually have a completely free of error data set for training and validation. So we moved on that, and I want to mention one important thing that I think can also bring amelioration to the actual enforcement of the AI Act. We touched on governance and enforcement also. I will not delve into that. It will take too much time. You will see it in the report. We already moved a bit in strengthening the role of the Commission on transnational cases. But also we have strengthened the involvement of the stakeholders, those that are also here today, in all phases. For example, when thinking of updating the Annex 3 or in the work of the board, in the national authorities' activities, we ensure that there will be more permanent involvement of all stakeholders in the chain of the AI. Obviously, one last point, US-EU alignment will be very important. We value that because it will strengthen our framework. It will, so it will be important, for example, to try to work on common standards and look at how we can align on the high-risk uses. And I have to say, I found, in general, from all over the world, a great attention from colleagues, legislators from different parts of the world, the attention to understand this model that we are trying to build based on the risk classification and with the idea of building on trust. This is especially important in democracies because people don't want to be manipulated or to be seeing their fundamental rights violated by things that they don't even understand. So it's quite important that we build trust. This was our, I would say, inspiration also for this first phase of the work.
Killian, I was also curious about this thing for data sets that they need to be free of errors when you use for in a high-risk application. Again, what was the thinking behind that? How is that actually feasible?
Well, the formulation free of errors was probably an error because we we had so many remarks about this. In the text, what we meant, and if you read the text together, but I see that it was, I think every report has changed it, I've seen so far. If you read it together, it's part of the quality management. And you read Article 8 and 9, and there we refer to state of the art. So for us, the articles need to be read together. So technically speaking, I think what we try to say is that the data sets should be state of the art, as good as you can do them. And that is, I think, expressed by this context with the quality management scheme, which is described in Article 9, where we speak about state of the art, and this is the data requirement is part of this. I see from the public reaction that this idea was not getting across sufficiently clearly. Therefore, I think it's wise to iron this out and to clarify this. Yes.
Okay, so you're going back on your previous idea. You're happy that it's being amended.
Yeah, well, we are always happy. I mean, we table a proposal and then additional wisdom comes to it, and hopefully then afterwards...
Even if they are not happy, it's us that decide.
Exactly, exactly.
Claire, going back to this geopolitical question, this race for AI, to what extent do you side with Axel or Brando on this idea that we shouldn't lose our edge?
Well, we think that innovation is often a justification for soft regulation. And to your question as to leaving society deciding, who in society are we trusting? In a democratic society, are we trusting to decide to be the bearer of our values? Why would we trust companies, technologies, however well-intended they are, to be deciding, how this will affect people's life? How are we trusting when we see that companies have constantly been pushing from harmful uses of AIs, when we have Clearview AI, selling images of our faces, when we have Amazon using algorithms to fire and hire employees, when we have AI lie detectors being pushed on migrants and people on the move, because companies are mainly, motivated by making profits. And so what we risk to do is just giving a blank check on the name of innovation that would lead to further harms. And we cannot be, as society, just a place of experimentation, especially at the expenses of the most vulnerable and marginalized of us. Imagine if we would say that the aviation industry or the chemical industry would be free to innovate in high-risk cases without any regulation. So that's also why not only technical requirements are important, but most of the risk happens at the phases of the use of the system. So that's really why we believe in fundamental rights impact assessments that would clearly to demonstrate in high-risk cases what the impact on categories of population would be. And to use an image, if we would say, because a medicine has received an authorization to be placed on the market, it would be simply safe and fine for any patient to use it. While actually, before using a medicine, you receive an actual prescription for a doctor, and it is also verified by a pharmacist to know if it's compatible with any other treatments or condition. So that's why we are, also saying that at the stage of technical requirement, that's simply not enough to assess all the risk. You need proper assessment on the impact on society, and you need individual rights to complain and to get redress.
Killian, there's this issue of self-assessment from companies, and I'm just wondering if the Commission, there's also limited restrictions for governments or government agencies like law enforcement using some of the high-risk applications. To what extent is the Commission just too trusting of companies and governments for complying with the rules?
Well, I wouldn't put it like this to say that for public authorities in the law enforcement areas we have lighter touch rules. I think what they need is, I would call it specific rules. They are a specific sector, they have specific needs. When the data they deal with are particularly sensitive, so you don't want to bring this data to a market surveillance authority, that I can fully understand. So I think it would be a bit misleading to say what we suggest is that they get a lighter approach. I think what they need is a specific approach, taking into account their specific needs. And we should not forget, this is important. Public security is as well very important. Everybody who has followed yesterday night the debate, public security is for a lot of our societies an issue, and technology plays there as well a role, because the means our member states have are limited. On the self-assessment, to come back to this, we don't think that necessarily a self-assessment is in any case the weaker way. These are two ways of doing it. This is a classical approach in product legislation. You can have a third-party conformity assessment, or you can have a self-assessment. The self-assessment is not light, because if you get it wrong, you are liable, and we have very heavy fines, up to 6% of the turnover. So this is this you have to see. This is not an easygoing option where you can just do it. What we thought of when we set it up is that for the cases where we have suggested a self-assessment is basically that there is not yet the tradition or the system really to do the assessments. For products, this is well established, like for cars or for other products, we have all these bodies in place. Member states are used to it. There is a whole machinery around this. It's very easy to adapt this machinery to AI, and therefore we think, okay, then they should do now in a very precisely described way the AI assessment. For this pure software systems, this is not the case, and we would need to set up a whole machinery. Therefore, we are a bit prudent. But at the same time, I want to be very clear. We put into the draft regulation, which is just a draft, of course, we put in the option that whenever we think the Commission after consultation, of course, with stakeholders, believes that the self-assessment is insufficient, we can move to a third-party conformity assessment. So it's not, this will be, like, let's say, under scrutiny. So if it doesn't work, fine, we can always move to the other way, which I think is completely fair and correct.
I'm looking at the questions that people have asked online on the SwapCard app. There's one from Mark Breckel, who refers to something that was said by VP Crow from Google, who argued that the Act should clarify how we deal with general purpose AI systems, which are all the rage in AI R&D. How can we avoid a situation where all the responsibility for integrating American general purpose systems ends up with the European SMEs that make a small change and put their high-risk application on the market? I think that's an issue that's come up before. Brando, what would you say to that, to answer this question?
I think simply that we cannot let the general purpose AI be brought out, in fact, of the regulation that we are discussing. And I think the chain of responsibility should be balanced. Also, I have to say I'm very much in favor with the idea of a fundamental rights impact assessment by the user. I think it's a good idea. On the other hand, just to mention one thing that was touched that I think it's important, I didn't comment on that, is the emotion recognition. I think the approach that we heard from the Commission is reasonable, that we look at users where this can be feasible. I don't agree personally with the idea of a general ban, but however, I think that on cases that were mentioned, like the use in the workplace, I don't really see the benefit for hiring and firing people with emotional recognition. So I would personally think of looking at strong limitations to this when I don't see the societal benefit from this. And I think that on the workplace, we didn't talk about that today, still we need to strengthen the provisions. The lack of the reference to the social partners in the regulation cannot be covered by, I got this answer by an important political figure in the Commission, that the existing national laws will be anyway applied. But it's not true, because we already see a lot of problems and violations already happening, violating existing laws by using in the workplace AI without even workers knowing it. So further protections on that needs to be put in place when we look at the usage on the workplace and on the general purpose AI, I said at the beginning.
Yeah, there's been a lot of delay in Parliament actually on the AI Act. Axel, are we going fast enough? I mean, because AI is already here, like what are we doing?
So totally not. We are too slow, and I still have the feeling we do not have the will to survive in a digital age. And this is what I'm criticizing all the time. We need to come up with a kind of a plan and a concept, and this doesn't mean, oh, we have here the DSA, the DMA, and the AI Act. This might be quite okay, but how to execute all these in a way that our European digital industry and so on will really make a significant step forward. And this is what I'm totally missing. We are happy that we are now regulating here something and there's something and improving a little bit, but there is no overall plan and concept. And this is what I'm totally missing. And if we are coming now to AI regulation, of course, this has a kind of a practical impact at the end. So if we are having these wide or broaden definition, all of a sudden you find 90% of AI applications inside the scope, and this means high risk. And then you have all these requirements for AI systems, all these obligations for the deployers and users. And this is something I can't see. And even it's always nice to hear, yes, we have to evaluate fundamental rights and blah, blah, blah. But navigation system, I can't see how this might affect a kind of a fundamental right at the end? And why do we have to think about this is an AI high-risk system? And here I think we need to more differentiate, and I would like to push, but this is not Kilian's responsibility, but I like to push the Commission with a more overall concept. It's always nice that all our member states has a kind of an AI strategy, but how is this linking together? We need to join forces. We need to come up with European projects. Otherwise, I can't see that we will be a kind of a serious competitor to other regions in the world.
Thanks. Kilian, I see you shaking your head. Does the Commission not have a plan for AI?
I think this is a rather rhetorical question. Of course, we have a plan. I mean, I here have to contradict a little bit Axel. So what we propose is, and that we try to highlight in the impact assessment, is really a small minority of cases shall be high risk. This is what we currently, in our assessment, what we're discussing is 10 to 15% are high risk. That is, I think, a reasonable margin to start with. So it's not that we're regulating every system which is on the market. And of course, we tried to combine this with a strategy. We had this coordinated plan on AI, where we asked member states to develop a strategy. We have a strategy, so this is part of an overall context of the Commission, where we try to boost AI, but this, as Ms. Vestager, our Executive Vice President, put it, in the European way. And just perhaps to link up a little bit what was said before, one concern we have is a bit on the different aspects. We should never really see the AI really in isolation, but we need always, when we ask for obligations, what is already there. Because we are acting in nearly all areas, we are acting in highly regulated areas. And for instance, just as an example, the General Data Protection Regulation, which is normally applicable in these sensitive areas, because then you use personal data, is already restrictive. You have, you need consent, or you need, if you, for instance, there is a prohibition on the processing of biometric data, so that you need to take into account that you don't duplicate, or there is a data protection impact assessment. So whatever we create, we should look at what is there, and what we try to avoid is that we don't have, if there are deficits in implementing existing acts, that should not be compensated by now repeating regulations. So we think then we should reinforce the implementation of the act. If the problem is that, for instance, the GDPR is not always fully respected, that may be the case, but that should not be the argument to say then we need to re-regulate now, because we think the regulation is not the other regulations aren't fully achieving its objective.
Thank you. We've reached the end of our panel. It was very interesting. I feel like we could have gone on for much longer, actually. Thank you, Kilian, Claire, Brando, and Axel for taking the time to debate with us today. And thank you for joining me to discuss the EU's AI Act. If you're online, please stay connected. And if you're here, please stay seated for the next session with my colleague, Vincent Manoncourt, who will be interviewing Justice Commissioner Didier Reynders. So you're just aware this, because of a scheduling conflict, the interview was pre-recorded yesterday, but it would be broadcast live immediately. Thank you.